Ready, start. The phenomenon of false implication by way of making general omnibus allegations in the course of matrimonial disputes is not unknown to this court. Full stop. In Kausar alias Sonam versus State of Bihar, this court dealt with a similar case wherein the allegations made by the complainant's wife against her in-laws under section 498A and others were vague and general, lacking any specific role and particulars. Full stop. The court proceeded to quash the FIR against the accused persons and noted that such a situation, if left unchecked, would result in the abuse of the process of law. Full stop. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR/complaint is very well drafted with all the necessary pleadings. Full stop. The complainant would ensure that the averments made in the FIR/complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Full stop. Therefore, it will not be just enough for the court to look into the averments made in the FIR/complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. Full stop. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments and, if need be, with due care and circumspection, try to read in between the lines. Full stop. The court, while exercising its jurisdiction under Section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case but is empowered to take into account the overall circumstances leading to the initiation/registration of the case as well as the materials collected in the course of investigation. Full stop. Take for instance the case on hand. Full stop. Multiple FIRs have been registered over a period of time. Full stop. It is in the background of such circumstances the registration of multiple FIRs assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge as alleged. Full stop. Considering the dicta in Mahmood Ali (supra) we find that the High Court in this case has failed to exercise due care and has mechanically permitted the criminal proceedings to continue despite specifically finding that the allegations are general and omnibus in nature. Full stop. The appellants herein approached the High Court on inter alia grounds that the proceedings were reinitiated on vexatious grounds and even highlighted the commencement of divorce proceedings by respondent number 2. Full stop. In these peculiar circumstances, the High Court had a duty to consider the allegations with great care and circumspection so as to protect against the danger of unjust prosecution. Full stop. As stated above, given the facts and circumstances of the case, we find that the material on record is wholly insufficient to proceed against the appellants. Full stop. Accordingly, the impugned orders and the docket order dated 27/2021 are set aside and the criminal proceedings against the appellants are consequently quashed. Full stop. Resultantly, the appeals stand allowed. Full stop.